When we first were confronted with the phone call that came into David, we had a man in solitary confinement with no charges, and he'd been in solitary confinement for 4 months, from say December through March. And our initial petition, included a demand that he be charged, that you can't essentially throw a person in a dungeon and leave them there to rot, which was effectively what was happening with Mr. Hamdan. Moreover, solitary confinement is a debilitating condition. It is a species of torture, and it will have lasting and in many cases permanent psychological consequences that could destroy his ability to assist in his own defense. So these points were made forcefully to the court at the outset. And one of the points I want to make, and we'll make it as we move forward, is that the U.S. government was changing the conditions on the ground at every step of the way in order to try to moot our arguments to the court. And we'll describe how, when the moment came when they had to stand in front of a federal judge to justify their conduct, suddenly things would happen. Oh, he's out of solitary. Oh, we've moved him. Oh, we've charged him. Oh, the rules have been changed with respect to torture. The rules have been changed with respect to your presence. And we'll describe some of that. But I see a hand in the back.
I just had to ask, he wasn't just a solitary confinement, I'm sure he was interrogated.
Correct.
Was subject to the bright lights and then intensely loud music and whatnot. But you can just talk about that.
Yeah, well, I can't talk about that, to tell you the truth, because he was subject to interrogation, but we have not seen that file, and we do not know whether Lieutenant Commander Swift is aware of some of the files that came out of the interrogations or not. I'm not sure, but we don't know that. We have to assume that he was. There is an openly filed affidavit from Mr. Hamdan that was initially filed under seal with our petition, but Judge Lasnik unsealed it, indicating that he had been held in extremely cold conditions. He had been forced to sit for many, many hours in these stress positions that we've read about in the press as part of the authorized interrogation technique. That he was subject to threats of death or bodily injury with a loaded pistol placed on the. Interrogation techniques that were designed to intimidate. Whether this calls into question the whole interrogation policy, and we can come back and talk to that, because I think what the Supreme Court ultimately held concerning the application of the Geneva Conventions, and specifically Article 3 of the Geneva Conventions, what they held has very profound implications for interrogation policy. But there was a little bit of that involved here, but primarily the solitary confinement issue was what we brought to the court's attention at the outset.